Madam President, this is Dr. Osgood. I'm in my car in transition, so as soon as I get home, I can get on the computer on my screen.
We're just glad to hear from you, DACA. You had one or two things to take care of, so we're just glad that you're on. We appreciate you, absolutely. Okay. I want to thank everyone for joining us. And welcome everyone. We will begin with our self-introductions. Anybody can start.
Colonel David Holmes, Broward County Sheriff's Office, Executive Director for Department of Law Enforcement.
Elder Mathis, Dice Faith Community.
Alona Holmes, NAACP.
Michael Bell, Community-Based Connections.
Hold on, Judge Williams.
Yeah, I'm sorry. Elijah Williams, Circuit Judge Delinquency.
Thank you, sir.
Ella Phillips, DJJ Advisory.
Repeat, Mr. Obel.
Rosalind Osgood, Broward County School Board.
Thank you, Doc.
Michael Bell, Community-Based Connection.
Thank you.
I'm Valerie Wanza, Chief School Performance and Accountability Officer, Broward Schools.
Thank you, Dr. Wanza. Is that everyone?
Gordon Weeks, Public Defender's Office.
Yeah. Go ahead.
Gloria Michelle, State Attorney's Office, Juvenile Division.
Okay, say again, Gloria, we could barely hear you.
Sorry, can you hear me?
Yes, I can now.
Okay, Gloria Moschella, State Attorney's Office. And I'm, I don't know, I'm sure you might be aware, Madam Chair, Harold is not going to be able to attend the meeting, but I do have some communication I want to be able to provide to everybody on his behalf.
That's interesting. He didn't share that with me. He's the star of the show today, so I hope you'll be able to fill in. That's very disconcerting when it wasn't.
I think he has his hands
Talk about
full
that
with the new prior to the addition to the family and some other matters he was taking care of all morning.
Yolanda
Yeah.
Brown.
Okay. I'm sorry, Ms. Brown, go ahead. I apologize.
Yolanda Brown, Court Administration, community member.
Dale Holness, Broward County Commissioner, District 9.
Thank you, Commissioner.
Travis Lagon, Department of Juvenile Justice Camp Coordinator for Prevention.
Thank you, Mr. Lagon.
David Watkins, Broward County Schools.
Thank you, Mr. Watkins.
Johnny Sanders, DJJ Prevention.
Oh, are your screen off, Mrs. Sanders? I can't see you.
Yes, it is off, Madam Chair. I just ran out for a late lunch. So I didn't want you guys to see me in the drive-thru get my Impossible Whopper. So do pardon me this afternoon.
Okay, we'll give you time to get back to your spot. Okay.
Thank you so much.
Thank you. That's hilarious. Thank you. Okay, so we are going to be reminded of our norms. Cell phones placed on vibrate or silent, please. Raise your hand if you wish to speak. We're going to speak for a maximum of 3 minutes per person. Respect all opinions and viewpoints. Address other board members respectfully. And we will go from there. Wanted to say I have, it's my fault, I've been extremely busy. I can't remember. I don't think I sent out the 3-year comprehensive plan report again. I will get to that. We had a couple of things on the agenda for at least last 3 weeks. We will do that. Mr. Lagon, I will get you a copy of our document that you're waiting for from last year as well. We had a couple of things going on in Broward County that we needed attendance. I haven't forgotten about you. We'll get it taken care of.
Thank you very much.
Okay, so it was at this point I was going to start with Mr. Pryor on these documents. So let me since he's not in, let me do this. Our subcommittee report. Let us hear from our subcommittee. Mr. Weeks and Judge Holmes. Since our last, I want to do a recap of what we said we were going to do, and let us know what's actually done. And if you check your emails at 3 p.m., I scheduled some emails to go out. You will be able to see the documents that I have been provided. I understand there may be additional documents. And if there are, there should be at least one other document from the state attorney's office. Ms. Motella, I expect to see that pop up shortly, if you don't mind. And so we'll all be reviewing these documents and going line by line, but I'd like to start with our subcommittee, and then we'll go to the state attorney's office. So Mr. Weeks, Judge Holmes, if you would.
Thank you, Madam Chair and Madam President. If you would allow me to share the screen.
You should be able to.
I have the authority. I was just wanted to ask
Yes,
before I
please
did
do.
it. Can you all see the screen?
Yes.
Yes.
All right. This is the task that was given to the subcommittee is to review section 985.12 that mandates that a civil citation program be created for this community. It authorizes that program to be created by the state attorney's office in consultation with the public defender's office and the clerk's office. We all got together pursuant to some direction from this body and Madam Chair and some guidance from Judge Holmes, and entered into this agreement pursuant to the statute. This agreement went in effect on May 1st. I'm going to scroll right down to the signatures. It is fully signed by all parties. It has been distributed to Madam Chair, and I believe the question for this body today is whether it's going to be adopted and then be forwarded over and housed with the county, because the county is going to run the civil citation program for Broward County. Jess, I'm going to go through the agreement really quickly, but it'll be available for all of you to review in greater detail. The introduction talks about a little bit about why it is important to have a civil citation program in this community, the purpose of the civil citation program in this community, to make sure that we offer children that commit misdemeanor offenses to get the necessary addressing of their issues, but not burden them with a criminal offense history, and offer them an alternative, which is a civil citation to arrest. The stakeholders that were involved in this process were a number of people: the state attorney's office, clerk's office, law enforcement agencies, Circuit 17 Advisory Board, the county commissioner. We have a representative, Commissioner Dale Holness, the NAACP, the Department of Juvenile Justice. All were able to give input in drafting and creating this plan. This plan has acknowledged that it will be operated by an independent program operator, not someone from the county, not someone from the public defender's office, or strike that, not someone from the state or from the public defender's office or from a law enforcement agency, but from an independent operator, being the county. The county has agreed and put significant resources towards supporting the civil citation program. We're very thankful that we have a supportive county, and through their Department of Human Services and Crisis Intervention and Supports Division, they are the operators of this program. We wanted to make sure that we were very clear that there would be no fee involved in this program. This program is cost neutral, and folks should not be prohibited from participating in if they can't afford to participate. So that was a very important criteria. The eligibility criteria is pursuant to statute. Those folks that commit eligible misdemeanor offenses, they're under the age of 17 years of age or younger. The offense occurred in Broward County, and you may participate in the program up to a maximum of 3 times pursuant to statute. The eligible offenses are clear: qualifying offense of assault, misdemeanor battery, misdemeanor resisting arrest without violence, disorderly conduct, disruption of a school function, petty theft, resisting retail theft, under $750. That is a misdemeanor. Trespass, misdemeanor drug possession and drug paraphernalia, loitering and prowling, which is a misdemeanor, criminal mischief, possession of alcohol by a minor, misdemeanor, misdemeanor traffic violations that are state offenses, and violation of city or county ordinances, those misdemeanor violations. The non-eligible offenses are all felony offenses are not eligible for civil citation. And there are very few misdemeanors that will not be eligible. That will be misdemeanor offenses involving possession or use of a firearm or deadly weapon will not be eligible. Domestic violent offenses, and there's a caveat to the domestic violent offenses, and sexual offenses will not be eligible. Just going back to domestic violence offenses, although the domestic violence is a nuanced area, there will be some review on those to make sure that it's not a technical domestic violence, but could also be just a regular battery, and then make them eligible, because a battery is in fact eligible. What causes it to be a domestic offense is that they are domiciled together, I mean, they live together, and there may be a familiar relationship. So some of those still may qualify. There is a data review component for this program. They will collect data, we'll analyze that data, and there will be a quarterly presentation of that data with an emphasis on the missed opportunities. Because in order to determine whether this program is working, we got to determine which children would have qualified and did not get an opportunity to participate. So there's a section on missed opportunities. Although this program is the program for Broward County, we have learned through experience that there will be instances where children are not afforded the opportunity. So we wanted to encapsulate that in this agreement. And this agreement has some further work that needs to be done. One of which is to create a process where the clerk and the state attorney capture those children that could have received a civil citation but did not, via a notice to appear or an out of custody arrest, that those children get evaluated. It's my understanding, I don't want to speak on behalf of the clerk, I'll strike that on behalf of the state, but it's my understanding the state and the clerk have had conversations, and there's agreement that should be forthcoming sometime this week to memorialize that process. There was a further requirement that the state, along with the Department of Juvenile Justice and the sheriff, create a process to identify those individuals that are brought to the Juvenile Assessment Center and to make sure that they also receive a civil citation. A lot of conversation was had around this area. Judge Holmes emphasized the importance of not taking the ride, because the ride is also equally as punitive as the actual arrest. And taking a child into that facility is the functional equivalent of an arrest, even though you're going to receive a civil citation. There was some conversation at the subcommittee last night, and there was proposals submitted by, I believe it was the Department of Juvenile Justice along with the county, and accepted by the state, that the state would issue a memorandum, or strike that, a memo, to all law enforcement instructing them that they are to utilize the program as embodied in this agreement, and instruct them that if they don't, they would issue the civil citation, and encourage them not to give the child a ride down to the detention center. I do not have a copy of that agreement. That agreement I think is forthcoming, or strike that memo is forthcoming from the state. And when it is forthcoming and presented, I will present it to Madam Chair and the rest of the body. So that is where we are at with respect to this civil citation program. I was going to turn it over to Mr. Pryor to give the update on the state attorney's agreements, but I will turn it back over to the chair or Judge Holmes for their input.
Judge Holmes, I believe there were some, you had initially had some concerns, and have those concerns been addressed?
I still do. I told the committee in April when they were promulgating and typing this up, that there was a problem. It does not really track 985-12. I said the same thing on May 5th when we met. We were supposed to meet yesterday, but Mr. Pryor canceled the meeting and then he brought it back on. But by then I was on the other things. I'll tell you the issues that I have. There's too much loopholes. And you heard Mr. Weeks say, well, they're going to get together and do this. They're going to get together and do this. That's not a plan. The plan is you put it in, you delineate what every stakeholder, every person that's named in the statute, their responsibilities. There's very little responsibility in this document for the clerk. As a matter of fact, when she appeared at the May 5th meeting, she said, what's your statutory authority for asking me to do this? So that already told me that she was not, even though she signed this, if I were her attorney, I would have told her, go on and sign it. It looks good. It's a PR move because you're not held to do anything. To say I'll participate with the state. Well, what's participation? How's that defined? Her role is not clearly delineated in this signed document that has been put before this board. Further, there's no mention of law enforcement. I know Mr. Pryor said he was going to talk to all the police chiefs. I know Commissioner Holden has told him, I'll help you. I'll get you to the people you need to see if the law enforcement will sign on to this. But the statute makes it clear they can have their own program. They can promulgate their own, but it's subject to review by the state attorney's office to make sure that it complies with the statute. So there is no buy-in from law enforcement, even though the sheriff's office has signed off on it, because the sheriff showed up at a town hall and said, we're on it. His legal counsel said, we agreed to it in form. As again, I said, I would agree to it too, because it doesn't bind my client to anything. So this I would respectfully recommend to this board, do not adopt this. It's not a plan. It's a proposal at best. Until you get the clerk's office and law enforcement on board, and Commissioner Holden is going to come in real handy with Mr. Pryor, because Mr. Pryor doesn't know all the law enforcement officers and the chiefs. He's been to some of their meetings, but I firmly believe that Commissioner Holden can get him in with these city managers or city commissioners and have them push in their cities. But right now we're operating with what you've been operating in the past, but it's a lesser version because, the children are still being arrested. And you can tell that by the missed opportunities report. So as I said, it doesn't, those two areas, the clerk's responsibilities and what law enforcement needs to do, they can either come up with their own plan, and there's language that can be added to that. There is some discrepancy as to, okay, if they take a child to the JAC, you're going to have some officers who make a mistake. Okay, they inadvertently do it. And there are going to be some, and we've named those municipalities, that don't care. They're going to make that arrest of that child and take the person to JAC. So what happens when they get to the JAC? There's supposed to be a screener at the JAC. There was some talk, I think Deputy DeMarco was talking and saying, well, Broward Sheriff's Office, we don't handle that. We're not doing the screening or anything. But what happens when they determine, okay, this child was arrested, but we're not going to turn in the probable cause affidavit. We're not going to take the child over to the secure side. We're going to do the civil citation. There was talk from the state attorney's office that the on-duty prosecutor could issue a civil citation right then. And then the talk was, well, who sits with that child until their parent comes in? And then there was talk about, and at the May 5th meeting, DJJ was not present, but I think Deputy DeMarco mentioned something about staffing problems and money problems. And so I suggested, I said, well, look, if we need somebody there at Jack to watch the child so they don't go over to the secure side, why don't we go to the Children's Services Council and see if they'll give us some money, since I pay a lot of taxes. So, you know, I said that sort of tongue in cheek, but I'm told that the state attorney did ask them and they told him no, they didn't have any money for that. So, you know, I find it hard that they don't have any money to keep a child out of custody. So I don't know what his presentation was to them. So I suggested, Mr. Pryor suggested that we meet again on the 17th. And I told him that that should not happen because we had this meeting today. So we should meet again before, so that he could have everything mapped out and ironed out to present to this body, especially to the chair. I've not heard from Mr. Pryor. I've not seen anything that he is supposedly getting the clerk to sign, but all of that should be attached. We should leave nothing up in the air. This is so important. And you've been waiting all this time. You had it going up and going a little bit, and now it's like nobody's doing it. So I would suggest that this is not ready for a vote for acceptance. It is a proposal, not a plan. And that's just my legal opinion on behalf of the NAACP.
Thank you, Judge. Let us hear now from the, this is the part where I sense Mr. Pryor had multiple meetings. I went back and I listened to watch the video, and he talked about agencies who he met with. He talked about meeting with the clerk's office. He talked about an MOU. So let's hear from Ms. Marcello. What exactly has the state attorney done, and where are we? So, ma'am, you have the floor.
So he has met, thank you, Madam Chair. So he has met with both the Dade County Clerk's Office as well, of course, our Broward County Clerk's Office. Some of you may be aware that the Broward County Clerk's Office did meet with the Dade County Clerk's Office to understand the process down there for civil citation. Once they were educated on that, they seemed to be very much on board with allowing us to process, or having them process those cases so that they not process those cases so they come directly to the state attorney's office. Where we're at with general counsel for the clerk's office is that she will be presenting a one-page agreement with the state attorney's office along with a proposed order to Chief Judge Tudor either today or by the end of the week for him to sign. That would allow the clerk's office or require the clerk's office or permit them, however the clerk's office wants to word it, to hold those NTAs and send them over to our office for review and processing. That way they would not be assigned a case number. I presume, because I was not at the meeting with Miami-Dade, but I presume that's in aligns with however Miami-Dade is doing that.
Can I ask a question? You said NTAs, that's notice to appear. We were discussing NICs, not in custody cases that the police officers, that has to be covered too, because they could get arrested on that.
Well, what happens with the not in custodies, Judge, is that I don't know if that might be a conversation that you had with Mr. Pryor that I'm not aware of.
Yes.
If you're referring to not in custodies in general and in juvenile, that they do end up at the clerk's office by accident on some occasions, right? Those cases, we've had that issue, but that's an aside from the civil citation issue. We're going to have to address that separately, I would think.
Well, Mr. Pryor is the one that brought it up in our conversation.
Okay, probably because I will get back with him on that, Judge. Probably because I've brought it to his attention that sometimes those cases, the law enforcement officer seems to think that they have to present the not in custody PC affidavit to us and to the clerk's office. And then they get assigned a case number, even though they really shouldn't. I am aware of that. I actually brought that to Mr. Pryor's attention. So I will revisit that with him and see if that was part of their discussions. But with regard to the civil citation, the idea would be that they would provide those.
Hold on one second, Laura. Let me back up here. So the judge, a problem was certainly the NTAs. I thought you all were going to discuss that, because if you had a case that came that was at the clerk's office and the child did qualify for civil citation, that should have been part of the discussion already. So was it, and what was your agreement on that?
Are you referring to not?
I was talking to Judge. You said you
Okay.
were not there. I was talking to the judge.
Okay.
Please.
Mr. Pryor said he was going to look into that and get back to us, and you know, because he is the one that brought it up to the group. So I took notes of everything that he said. So that's why I asked Miss Gloria. You know, you said NTA. NTA is a notice to appear.
Right.
That accesses as like an arrest warrant, arrest affidavit.
Mhm.
So, you know, if officers are giving children NTAs, notices to appear on misdemeanors, that's an issue too. That's a problem. But Harold brought up the not in custody capiases that for misdemeanors. And I said, well, Harold, your office has the control over that. So I don't know what he's thinking. Is he mixing the two? Because they are different.
I don't think so. I think what it is they're not capiases. They're just not in custody probable cause affidavits that should only come directly to the state attorney's office. But some officers, very rare, it doesn't happen all the time. Again, educating law enforcement at the ground level, will drop off a PC affidavit to both the state attorney's office and to the clerk's office. And then that's how it gets on, you know, let's say Ms. Brown's radar. That's always been an ongoing thing. And I think Harold is now just trying to really address it. But that's separate and apart from the civil citation matter, which is what we're trying to develop with the clerk's office. This idea that they're going to send over anything that would have been civil citation eligible to us directly prior to, you know, assigning it the case number. So there's going to be they felt the best way to do that would be with this agreement along with a proposed order to Chief Judge, because I don't believe, and Judge Holmes, you could correct me. I was in one meeting last week with the clerk's office and Mr. Pryor. There is no statutory authority that would allow the clerk's office or require the clerk's office rather to do this. I think it has to be by some type of order and agreement.
What I did at our meeting, when Mrs. Foreman brought that up, what was her statutory authority?
Mhm.
I asked Harold, had he talked to Kathy Rundle regarding how they do it in Dade?
He had.
He said that he had.
Mhm.
Okay. Then I said, well, if you had, then you would have known that Mr. Reuben's office is in on this. And somebody should have talked to him to find out how he's doing it. He's the same statutory constitutional officer that Mrs. Foreman is. And so I wanted to find out how they're doing it. What statute are they relying upon or not relying upon? How are they getting around this? Okay. And so that's where we left the May 5th meeting, that he was going to contact, and even Mrs. Foreman said, I'll contact Uncle Harvey and see what he's doing down there.
They did.
So that's where we left it, but nobody was saying, you know, I just wanted to, look, if they tell me that this is the statute that we're using, all I need to do is take a look at it to see, is there some wiggle room in this statute to implement that in Broward County?
I don't think they're
But
using a statute.
I don't know what they're doing and how they're doing it, but they're getting it done. They're the number 3 leading county in this state that are not arresting juveniles like we are. So I don't know. Yesterday's meeting was supposed to be Mr. Pryor telling us about what he found out from the clerk, what they're going to do. So, you know, like I said, he canceled it, and then I was on the other thing. So I didn't make that meeting, and I was told it was like a 15-minute meeting.
I wasn't at a 15-minute meeting yesterday, but from the meeting that I was at with the clerk's office and Mr. Pryor, it appears to me that it's not by statutory authority, even in Dade County, that it is by only agreement with Ms. Rundle's office and the clerk's office, and that they had no problem in Dade County signing off on that agreement and with the letter from, State Attorney Rundle. And so that's why I think in our county, that's what they're going to do. They're going to do the agreement with our office with a proposed order signed by Chief Judge, which then I believe makes Ms. Foreman feel that she then has the authority to do that. I know that they seem to stress that they wanted it to come from the Chief Judge, because then I think they feel that gives them, the way that the general counsel is speaking, that would give them the authority to do that where they have no other authority. And so that's supposed to be done by the close of this week. And Mr. Pryor plans to have the clerk send that agreement for collective review to all of you and, obviously to us. And that's what he
No,
wanted
when
me to
he's
inform
gonna
you on
send it,
that.
Gloria?
I'm
When will he
sorry?
send the agreement?
It's supposed to be by no later than Friday was his understanding, because general counsel was supposed to be submitting it either today or by Friday. And then he wants it to be provided to all of you as a whole, to the whole group. So that's what I have in my notes here from Mr. Pryor on that. So that's moving forward. I don't think that's going to be an
We
issue.
are at a snail's pace here. This is, I don't understand this. I don't understand this. When I talked to him, but he's not on. So when I did talk to Mr. Pryor, he had received the documentation, the full packet from Miami-Dade. He said he had a clear direction in which he wanted to go, and he was simply going to make it happen. That's been,
well, I think he is making it happen because general counsel is going to provide.
this is taking way too long, Gloria, way too long. And this is, and I will talk to Mr. Pryor, but this isn't what we talked about as far as moving, because kids are being, we look at the missed opportunities report, we'll see that and as well. And so, there's an urgency in this in my mind that we should be doing. Okay, so let's do, you said that's it for this document. So let's go around the horn and have some questions, comments, and feedback.
I did want to address, Madam Chair, just that he is going to meet with the Broward Chiefs next week. He's going to be explaining to them the civil citation program, as well as the MOU with regard to the arrests of minors 12 years of age and younger, and the pre-screening process. And it looks like we're also going to take Ms. Gaynor's advice and do another proposed draft for a memorandum directing law enforcement again to check in with the JAC and or our office for a pre-screening before they issue any NTAs or make an arrest for an
hold off on that. We're going to get to that next document for a second there. So let's go with, let me hear from Colonel Holmes on where we are on the civil citation piece. I would hope that, and I don't know, I wasn't at the meeting. So, and I don't think you were either on yesterday's meeting regarding, because I think you're, and Judge, and go ahead and help me, your comments from their GC gave somebody some concern here. So, let's hear from the Colonel on this piece. I'm not sure, Colonel, are you getting those notices for the subcommittee? Because I certainly would want to, I understand that your GC was there, but GC is not law enforcement.
No, I haven't been receiving them, so I'm not up to speed prior to our meetings that we're having right now. But I know in reference to the current MOU that was forwarded to our general counsel, initially he approved it. However, there were some concerns, some questions that came forward. And I know right now he has a question that's in with one of the ASAs right now, and he's waiting for a response before we can get it out to our deputies to make sure we're all on the same page. Thus far, we've been patiently waiting to get this out. I mean, we have buy-in from the sheriff's office, and we have a process in place where we're going to make sure that it's in our policy that our troops have to follow the proper protocols with issuing of the civil citation. But this MOU will lead the way, and hopefully we can't control the buy-in from the rest of the county, but we can definitely take the lead and lead by example and make sure that our troops our deputies are doing it the proper way. We've had several arrests recently where we did issue some civil citations. I think for the month of April, we issued 8 out of 16 that were issued throughout the county. So it's 50%. But for us here internally, it's more of everyone being on the same page and having clarity with the MOU and having all of the legal aspect of it in place. So, our general counsel, Terrence Lynch, is waiting patiently to coordinate with the state's attorney prior to make sure that is accurate.
Thank you. I agree that I don't know how he's presenting it when it's not done yet. And I know that there's confusion because I was at Fort Lauderdale PD's office at a different meeting and we talked about the concerns. And I asked, I know that their SOP looks the same as when we got with their GC to write the policy probably about 9 years ago, and they're not working. It's not up to statute right now. And I was told, well, we remember. So I know we got something from the state attorney, but I don't really know what he's asking. So can y'all send us something? So there's whatever it is that's being presented is not clear, and it makes sense because the document isn't finished yet. So, but I appreciate you, and hopefully we will be able to get on the same page soon. So thank you, Colonel. Let me hear from Judge Williams.
Again, I don't know if you can hear me or not, but
We can.
I think when Ms. Michello, and I'm probably echoing what you individuals have already said, but when they're going to get Judge Tudor to hold those NTAs, the NTA in and of itself is the arrest. You've already got an arrest if he's signing an order holding an NTA. So again, I'm confused. My IQ, I always say, it used to be 142 in college. I took one that's 138 since I've been in delinquency. I'm going down. I can't see why or how Judge Tudor is going to sign off on that this coming Friday. However, I tend to, he stays out of my business. I stay out of his business. So again, I'm not going to intercede. He'll do his own legal analysis, which I'm pretty sure will be very, very, very good legal analysis. He's much wiser at this than I am, and I'm not being sarcastic. He is. That's why he's the chief judge. But I'm just curious to see this administrative order that he's going to sign, and I'm not going to say sign it, don't sign it, that's his call. But my understanding when I went to judicial school, the last conference about a year and a half ago, I was on the executive board. They told us to stay out of this whole area of juvenile delinquencies. I'm sorry, citations, that we have no place, no part, no role in this. But again, if the clerk of courts has an arrangement with the chief judge to sign off on it, by golly, I'm not going to stop it. I'm going to support it 100%. So that's my position. But what I will say to Ms. Michello, I don't know how to, I can only tell you from my past experience. If you're going to go to the chiefs of police with this agreement, you have to get their legal counsel, Brad Wiseman, on board. All you need to do is when you walk into the room is say, chiefs, this is my plan. You don't have a choice. You have to have a civil citation plan. Either you join my plan and give them the 3 reasons why your plan is the best plan, or you better come up with your own. But Mr. Wiseman will tell you, you have to have a plan. So at that point, again, tell them this is my plan. These are the 3 reasons you better sign off on it, or you better come up with your own. But the general counsel will tell them when you leave, he's right, you guys, you gotta have your own. It's cheaper and quicker. Join Harold Pryor's plan. You walk in there just telling them about your plan, you're gonna walk out of there empty-handed, I can guarantee you.
May I respond, Madam Chair?
Sure.
So I just want to, once again, I've said this many times in the past, most agencies already have a civil citation policy in place. The problem to me has been, and I think Ms. Gaynor would agree with this, is at the ground level, it is not being utilized the way that it should be utilized. And I do believe that this proposal that we put together through the committee, the subcommittee, will be addressing that along with, Harold, who has met with every chief of law enforcement agencies in Broward County already personally, and then plans to present it again at the Broward Chiefs meeting next week. But at the ground level is where it's going to be important for chiefs to then have at their roll call, as Judge Holmes has referred to in the past, explaining to them that this is what is supposed to be happening in the streets. The fact that it gets to the clerk's office is not because anybody is trying. When it gets to the clerk's office, it's because it was missed in the street It was missed at Jack, and now it's at the clerk's office. The thing that we've been trying to undo, which I think we're going to successfully do with this administrative order, is not have a case number assigned so that it does not remain in the juvenile system and does not look like that child has something on a prior criminal case on their face sheet. It will come to our office where it will not look like that child ever had an arrest. Obviously, nobody wants it to ever make it to the clerk's office, because if they're doing what they're supposed to do at roll call from the top down in every law enforcement agency, by the time this committee gets through this, and Harold has made it clear to all of the chiefs in all of the municipalities, we should see less and less getting to the clerk's office. But we have to start somewhere, because we've never done it we've never been this detailed in our involvement. And so I do think that this is going to work in that direction. But to Judge Williams' concern, I don't think that it's a law enforcement agencies not being on board, because we already had a lot of them already on board, including a couple that were interested once we had sent out the emails trying to find out what each individual agency's policies were. So I don't think that's going to be an issue. Listen, if I'm wrong, you can all tell me I told you so. I got no problem with that.
Let me just say this. Let me tell you where I differ with you. Number one, yes, they do have civil citation, but we went through them. We got the copies from your office, and unless they changed them today, none of them were to statute. I think maybe Pembroke Pines was the only one that was close. They were not to statute. I said I was at a meeting with the chief and his senior staff just last week. They have no idea what Mr. Pryor was referring to about civil citation. They've asked us to share the information that we have. I know that he met with them, several of them, but I know for a fact several of those meetings did not go well. And yes, there were law enforcement agencies that are signed on, but they have low to no utilization of civil citation. And the county has just been trying to play nice to get them to participate and not calling them out. But I suggest that those days are over. So I understand what you're saying, Gloria, but that's not real when it comes to the street. Yes, he's had many meetings. Many of those have not gone well. I know that for a fact, and I have spoken to those. And I can tell you that there is not clarity in this proposal. It has, for whatever reason, changes, that sort of thing. Nobody is up to date other than maybe one police that's possibly Pembroke Pines. So I get where the issue is. We just got to do better, and we've got to do some clarity on here, because it's not happening right now. Let's go on to Commissioner Holness.
Yes. Thank you very much. I'm unmuted now. Yes.
Yes.
Thank you. I have a question for Judge Holmes, and thanks for your presentation and educating us on the issue. In terms of the signers from the city side, the police department, will that signature come from the police chief, or will it come from the city manager on the city side? Who's responsible for that signature?
It's supposed to be the police chiefs, but if they're in a city where the city manager is the manager, we would need both. I think that's the legal way to go, to get both of them, the commissioner and the chief, to sign off on it when we're not clear. But for
the city manager, not the commissioner, but the city manager.
Yeah, but you know what? The police chief's signature on that memorandum of understanding is more ministerial and what we call symbolic, that he's buying into it for his troops. So that way the city manager doesn't look like he's bossing the police around, even though that's his or her job. But it depends on the city. If they have a strong city manager, you want that person's signature on there. But the police, when the rank and file see it, they say, okay, the chief signed off on this too. And it makes the chief feel, okay, I'm going to make this happen. This is my city, so it depends on the city. For instance, Broward County, even though the sheriff's office is a part of Broward County, we didn't need Bertha Henry to sign off for BSO, because the sheriff, he's in control his men and women in his
That's correct.
department.
That's
But
correct.
some
And he's,
cities, you know,
yeah.
you don't know.
And the sheriff's elected directly. He's not hired or fired by Bertha. Whereas in the city manager situation, he hires and fires the police chief. So that's the reason why I asked that question.
Right.
At the end of the day, the person who the chief of police is directly accountable to is that city manager.
I know, but Commissioner, it looks good to have both signatures on there because when the your Supreme Court during the time civil rights, we're still in the time of it. But for instance, when the Supreme Court issued an order, for instance, the Indian nation sued the United States government when Andrew Jackson was trying to inter them and put them on reservations. The Supreme Court sided with the Indian nation. And so Andrew Jackson said, look, you signed the order, you come down here and enforce it. So you see the symbolism of having both the chief and the city manager, where the city manager is a strong city manager. So that's the only reason why I suggested that. But the city manager can sign off on it. But if you got a chief that says, okay, you signed it, you enforce it.
Understood.
So,
Understood.
okay.
Understood. So both of them would be good.
Yeah.
And the other question I have is Children's Service Council not having money for ensuring that these children are taken care of. How much was it going to cost? Do you have any idea? Anyone knows?
I don't know what Harold said to them. That's why he was so needed to be here. And you know, that came to me by, I guess it's hearsay as to the 15-minute meeting that they had yesterday that he had canceled, and then he said it's back on. But he said that somebody on the Children's Services Council said they didn't have the money. And so it could be, we don't have Mr. Pryor here to tell us, what did you ask them for? And who did you ask? Okay,
if I can get that if I can get that information as to how much it cost, I will call Ms. Cindy Arenberg myself directly, because it would make sense to me that that's an investment we want to make. It would be, in my mind, foolhardy for us not to invest in saving our children or future by getting them through a program such as this that is as successful as it is, rather than destroying our children's lives and reducing the productivity of our people going forward. That makes no sense to me that we can't find. I don't know that it can cost any more than $100,000. I doubt it'll even cost that much, maybe 60, 70,000.
Chief Evans, I heard DJJ's name called several times. I know you were at the majority of the meetings. Where is DJJ in this proposal? And do you have some thoughts? Do you have some concerns? Can you address the question of the staffing issue? Anything you could share with us?
All right, good afternoon. Thank you, Madam President. And I forgot to announce myself. So Cassandra Evans, Florida Department of Juvenile Justice, Chief Probation Officer, just for the record. So I participated with the subgroup and to the issues that are before us today, specifically about the cases where the law enforcement officers choose to bypass the statute, bypass even maybe their local SOPs, and then determined to still write the arrest report or probable cause affidavit. I looked at some data and it's 50-50 if it comes to the JAC or not. The going to the clerk of the court matter has obviously been very difficult because of the assignment of the court docket number and how do you work around that. So again, to the question as it relates to what's happened in Miami-Dade, I truly believe that has all been by agreement and nothing statutory, right? From its inception many years ago. So the department would really, in those type of situations, if it processed that way and it was held and a civil citation was issued, then it will appear in our database when it gets to the point of Tamika's Office of Justice Services entering the referral on the prevention side. And so the department would be certainly pleased to see that happen. As it relates to the Juvenile Assessment Center, as Tamika and I really delved into the process of currently how the system is designed there in the I guess the accommodations of the facility, we run into the whole issue of taking the kid into custody with the intent of arresting, the ride there, and then arriving at a secure facility and trying to undo that entire experience, and then legally trying to deal with the custody issue of transferring of custody. How do you go about doing that, so on and so forth. And so as it relates to the process, nothing is impossible. It is certainly challenging logistically and maybe even legally to undo what's already been done, right? As it relates to the department staffing on screening, we are there to screen children, and we will certainly advise even via phone call, or if the child arrives, if the child actually qualifies for civil citation. The staffing of any other non-secure section of the facility exceeds what the department currently has as a staffing threshold for those processes. And so that's kind of what it looks like. I mean, truly, if it was to be operationalized, and I know, Madam Chair, you and I in separate conversations and others of the committee asked about what we had planned to do many years ago. It may have happened truly statistically insignificant. I'm thinking maybe less than 10 times, if that many. When we created a civil citation area, the staffing was different. The layout and the utilization of the space at the Juvenile Assessment Center was different, and it has subsequently, it has been repurposed. And so we found ourselves not using something for many, many years, and I don't want to say resources were wasted, but they were, they've been reallocated at this point. So, so Tamika and I continue to brainstorm, and we came up with using Judge Holmes kind of echoing in our head, stop the arrest and the bringing of a child to the facility. And our goal was we said, well, hey, if we can do it for 12-year-olds, can we also do it for kids who qualify for civil citation? Make that phone call to the duty officer, stop the process, maybe facilitate some discussion in the community, get the parent involved, and get the kid released. If they felt they needed to bring a child somewhere because the parent was not readily accessible, then we the most appropriate community-based stop location will be the municipality and not the Juvenile Assessment Center, because we have a chain of custody that is transferred upon the child's arrival to the JAC. So that's kind of where we left the suggestions we left with Harold in the, I'm sorry, Secretary, State Attorney Pryor yesterday evening as a suggestion that was presented today. So that's kind of where we stand. And what I told him in that process, if that plan is accepted or we act upon it, then certainly I would in turn write a complementary policy that upon arrival to the Juvenile Assessment Center, we will also stop and ask those questions about determining the child's eligibility in the strong recommendation to civilly cite versus the process through the assessment center to prevent the child even coming through the Sally Port, which is a secured area. So long story short, that's kind of what we've done on our end to complement operationally what the body has asked of us to do and to meet the statute's threshold of requirements.
Ms. Gaynor.
Yes.
You had your hand up.
Mm-hmm. Yes, I just wanted to give a little bit clarity about what we discussed at the 15-minute meeting and why I thought it was so important that we had that, because I understand that there were challenges when it came to, according to the information we received, going to CSC and trying to obtain funding to staff the JAC when a youth is arrested, as opposed to offer the civil citation. So one of the recommendations that is made is that, much like the memo that went out for the 12 and under, where law enforcement is required to call the on-duty state attorney office and present what's going on with that youth before they actually put the handcuffs on and take them down, give them that ride down to the JAC. We propose that basically the same thing happens for civil citation when there's a misdemeanor. Instead of the officer who is, for whatever reason, making a decision that they don't want to offer the civil citation, for that officer to call the on-duty state attorney, tell them the situation, and let that representative from the state attorney office tell them, listen, you're not going to arrest the kid. Don't take the kid to the jack, because whatever legal language they would give from that office, you're going to offer the kid the civil citation. So that was that was the reason, that was the recommendation that I made, based on conversations that, again, I had with Cassandra, as well as some of our executive staff here at the county, because BSO had that same issue where law enforcement would pick up runaways and take them to CPAS. Well, CPAS became a babysitting service. And obviously the funding right now is an issue. So if we can stop that on the front end, because law enforcement is contacting the state attorney office and telling them, hey, I've encountered this juvenile who's committed a misdemeanor. I want to arrest because of this reason, and this reason. And the state attorney can say, no, you're going to offer that kid needs to be offered a civil citation because we're not going to move forward with a case like that. Then to me, that would help resolve the issue as far as staffing and funding.
Mr. Weeks and then Judge Williams. Mr. Weeks.
Madam Chair, I'll defer to Judge Williams.
Okay, Judge.
Ms. Gaynor, I don't like to air dirty laundry out. But last month I was a duty judge, and I do it about 3 or 4 times a year, all week, 24/7. I get the calls on, everything from homicide, search warrants, arrest, everything, all night long it goes on. So one night I was stuck because the internet in Plantation went out. So I had to go to Plantation Police Department and spend the night there. Make a long story short, I apologize to everybody for taking so long to get back to them because the internet went out. At that point, the supervisor went on, judges, you're not the problem. The problem is that the assistant state attorneys, we wait hours for them to call back. We're all waiting on them. The judge is up at 2 in the morning waiting on them. The cops are waiting on them. And so I called your number 2 or 3 person in your office last month, not to complain, but to let them know that that's out there. The point I'm telling you this is, if you have a system set up where your on-duty assistant state attorney at 2 or 3 o'clock in the morning is going to be waking up 3 or 4 or 5 times a night, you already keep, and I'm not blaming you, but the duty judge at BSO saying that you guys keep them waiting for hours. Now, it's not a criticism, all right? But what I'm saying to you is make sure before you take that load on of having your duty judge get that call, they're gonna be up 3 or 4 more times a night than they already are. And it's very burdensome for me as a judge to get up that many times at night, much less to start adding civil citation to their load, because already it's perceived as a problem with the sheriff's office. So just make sure before you agree to that you're going to be having your assistant state attorney wake up all night long. Okay, I'm just telling you.
Mr. Weeks.
Madam Chair, after hearing all of the feedback and the input from the body and the recommendation from Judge Holmes, I don't think this agreement is ready yet. And as such, I'm not the chair of the subcommittee, but I've been trying to be the writer, and they've tasked me as the secretary. So I do all the typing. I suggest that revisit this issue. I'm hearing some comments that probably need to be clearly delineated within this agreement. We're probably going to have to do an amendment to this agreement and attach all of these supporting documents. For example, the agreement between the chief judge, the clerk, and the state attorney's office needs to be attached. The agreement that Harold is going to create and send out to all of the law enforcement officers dictating that children should receive a civil citation where they are eligible. And we have to finalize that last piece of if we're going to need staffing, and Judge Williams raises a very important point. If you're going to need staffing at the JAC to deal with these children, rather than having a considerable delay for law enforcement calling assistant state attorneys at 3 in the morning, then we need to look at the funding. And we need to bring Children's Services Council into the conversation. We already have the county in the conversation to determine the funding. So I'd ask the chair to allow me to set another meeting and invite those additional parties to the conversation, get a finalized timetable of when these side agreements will be completed, add them into this original agreement, edit it accordingly, and produce a full agreement with all of the supporting agreements, and the conversation about funding the JAC to this body for review and adoption.
Okay, let's hear from Judge.
You know, I feel the frustration, and you know, I wanted this to be done, and I wanted to be done in a way that this community could be proud of it, and our children would be protected. But there seems to be a lot of nuance, and that nuance requires a lot of folks to speak on this issue in a affirmative voice. And it then becomes, well, let's wait until this one's signed. Let's wait until that one's signed. Let's wait until this one's signed. And it gets dragged out forever, and we're not getting it done. This went into effect May 1st. And as Judge Holmes pointed out, there's a lot of loopholes that you can slide through. We need to tighten up some of those loopholes so we don't have anybody sliding through it.
So I concur, Mr. Weeks. Let me just say, when I spoke to Mr. Pryor, I asked him, and how many lawyers y'all got down there? And he said something about 208, not including himself. And what was the number that you all had down there, Mr. Weeks, at the Public Defender's Office? How many lawyers I got down there? Like a smooth 150, something like that?
Yeah, we got about that. We don't have as many as they have, but we have a few.
So here's 208, you're 150. I believe that the sheriffs, they got about a smooth 15, 16, 20 down there. Commissioner Holness got a few down there. So I think between all these lawyers, you ought to be able to come up with something. And it's been months now. You know, we've been certainly more than paid. This is the low hanging fruit. We didn't even got to the top stuff yet. And so that's why it's very, very frustrating that we keep waiting for this, and children keep getting arrested and being denied an opportunity to participate. So yeah, this is very disappointing. And if I were to be honest, I'm pissed, because this is not what we were told this was going to happen. We were expecting much more. I can say that I am encouraged that the sheriff has done so far what he said he was going to do. But I'm not seeing that from the state attorney's office. And since the statute has changed, it starts with the state attorney. And I appreciate Gloria being on, but Gloria was not the one that the people voted for. And so this is what we've asked for him to do. And I'm quite upset that this has not happened. I mean, I don't know why it can't happen with all of this stuff when this ain't even a complicated portion yet. I do know for a fact that they got a huge packet from the state attorney's office in Miami-Dade County. They said they were on board. They talked to different partners. So I keep hearing there's a draft. I just got the draft today, but I'm not seeing the action behind it. So this is not good. Really, really not good. And promises not kept, commitments not kept so far. And so Colonel, is your hand up? Or is it still up from before?
No, I put my hand up, but I think Judge Holmes had hers up right before I put mine up. If I defer to her, she's still there?
Yeah, she said, go ahead. Go ahead, Colonel.
Okay, there's two things I want to bring up, and as the Honorable Judge Williams stated earlier, we really have to address this issue from two different angles as far as the enforcement by the law enforcement agencies. Number one, he talked about the state's attorney meeting with Brad Weissman, the attorney for the Chiefs of Police Association. Very, very important. When he speaks, they listen. He gets their attention. We must go at that angle, okay? The other angle, I know Judge Holmes spoke about it, was speaking with these city managers. These police chiefs report to these city managers. These city managers, especially the strong city managers, say we are buying into this program. We need enforcement from the officers. trust me, it will trickle down. If we take those two approaches, I think we can get results. Here at the sheriff's office, the sheriff is the main man. We fall under his guidance. However, we set protocols and made it mandatory for our deputies to contact Jack once they come in contact with the juvenile and they're considering arrest, to see if they're eligible for the civil citation. We're working on the MOU right now, and we're hoping that if we can create a policy where we have to mandate that they contact the state's attorney's office. Those are things that if we bring those together and take those two approaches that Judge Williams and Judge Holmes alluded to, I think that can make a difference from a law enforcement perspective.
Thank you. Judge Holmes.
I'm sorry. Thank you, Madam Chair. I just wanted to address something. You know, Judge Williams and I don't often agree on a whole lot. And today is one of those days. Judge Williams, any judge in Broward County has been sworn to uphold the law. 985.12 is the law in the state of Florida. So notwithstanding the fact that folks have told you that don't mention civil citation or that judges are not involved, that is incorrect. You're involved when any Florida statute is being violated. Your role is de minimis, but I also think that the chief judge's administrative order should mention something about, whereas this is the law in the state of Florida, and our judges are going to support the program because it is the law in the state of Florida. So any judge waking up at 2 or 3 o'clock in the morning, I think some of the warrants that they were giving me for murders, and I said, did you run this by an assistant state attorney? Well, and I knew when they hesitated, they didn't. So you're always going to get that. But at 3 o'clock in the morning, I've turned down warrants. Okay, so that's the judge's function for a whole week, to be 24/7 for the 7 days. But if the circuit buys in, and the statute does mention this circuit, but it doesn't make them mandatory. It makes the state attorney, the public defender, and the clerk mandatory people with this plan. Mm-hmm. But in every circuit, Judge Figueroa signed on to it in Tampa. So judges are buying in, the chief judges. So Elijah, I'm going to rely upon you to talk to those judges who are in the juvenile division and tell them to get with the program, that civil citation is here and it's going to stay. And that goes for everybody. I never did juvenile as a judge. I did death penalty. That's my specialization, death cases and murder cases. But I followed the law, whether I liked it or not. So it's here to stay because the legislature beefed it up in 2019. So it gave it teeth. So we got to follow it. So I would everybody just get ready. But as I said, Madam Chair, I would second Mr. Weeks's proposal to withdraw it at this time and let the subcommittee really delve into this. But it's not going to take long because everybody knows what our marching orders are. And now that Commissioner Holness has signed on to helping Mr. Pryor talk to those city managers, then I think that's going to take off. I'll do what I can, especially with the chief judge. If called upon, I will call Judge Tudor. But I want these younger people to know who to call and what to do. But this is mandatory. This is necessary. So I would second that motion to just withdraw it and let the subcommittee really do it and attach and incorporate by reference in the final documentation, all the memorandums of understanding to give it that legal status. So thank you, Madam Chair.
Okay, we have a motion of second. Is there any unreadiness? And we're going to discuss that. If there is, you have unreadiness, Judge. Give me 1 minute because we still have another topic we got to go on. So Judge Williams, get 1 minute, and then Commissioner Holness.
Yeah, 1 minute. Judge Holmes, I will just go ahead and I will say this. When we first came up with the promise agreement, Judge, believe it or not, the general counsel then the circuit says, we can't do it. We have no jurisdiction. Judge Williams, you can't sign this. Weinstein can't sign this. We pushed for it. We signed the agreement. I asked the chief judge to ignore those considerations. He listened to me. We signed off on promise. There's always going to be legal impediments, folks, or people telling us what we legally can do. We're talking about dealing with mass incarceration. I get that. If the chief judge were to call me, I'd say sign off, not a problem. That's not an issue. Ms. Gaynor, again, the comments I made about the ASAs not getting back to us, that occurred in January before Harold Pryor was even sworn in as the state attorney. That was under Mike Satz's regime. So again, this is a long-standing problem, and I just don't want to put more weight on those state attorneys at 3 o'clock in the morning, because like I said, not to complain, but in January, one kept me waiting for 2.5 hours while they were trying to reach that individual to talk to the detective. So that's all I'm saying, is that it's not a Harold Pryor issue. This occurred before he was even sworn in. So, but I appreciate your comments, Judge Holmes, but again, we find ourselves fighting lawyers, in my opinion, in order to progress our movement.
Commissioner, 2 minutes to the topic, please, if you have unreadiness.
Okay, no, I'm ready to vote no on to vote for this being moved forward to another time until we're ready. But very quickly, Judge Holmes, and maybe we can do this after the vote, and Public Defender Weeks. Do we have a framework or a document that we can get ready to have the city managers and the police chief of the cities sign off on, or does it have to be the same?
I can answer that, no.
Okay. Okay, so if we could get
You all
something
can
like
talk,
that.
You can join, perhaps join the subcommittee to
Okay,
discuss
all right,
this.
no problem, thank you.
Any other unreadiness?
We have not seen the document. Mr. Pryor is going to be working on that.
Okay, but to the topic, is there any other unreadiness? All those in favor of returning this document to the state attorney's office for further amendment? The board, members of the board, let it be known by the sign of aye.
Aye.
Those against nay? Ayes have it. Okay, so whoever's setting up the subcommittee meeting, will you include Colonel Holmes and Commissioner Holness so we can get moving on this? And will somebody, Gloria, I guess you will update Mr. Pryor on the latest developments. And if we could see the document that he's presenting, that would probably be great, because we are finding out after everything is done and it's not sufficient. So that's not really helpful. All right, the next document that was referred to earlier had to do with the agreement that's already been signed by the sheriff and by the state attorney's office, the memorandum of understanding regarding the arrest or detention of youth 12 years of age and under. Gloria, would you like to speak to that? I know you started talking earlier.
Yes, so obviously the sheriff and DJJ have signed off on the MOU. He has, our office has submitted it to the 18 other LEAs for law enforcement agencies for signature. Again, State Attorney Pryor has met with each chief individually on that topic and educated them on the MOU. I can tell you to Judge Williams' point earlier that as the state attorney who has to respond 24/7 to the MOU, I have gotten several phone calls in the middle of the night to wake me up regarding 12 years of children that have been taken in who are 12 years of age. So to the extent that the word is getting out there and that the policy is being followed, it has begun. I got a call as late as recently as last night at 1 o'clock in the morning, actually on a 12-year-old who, for the second time I've gotten the call on, and unfortunately is driving cars. He actually hit a city bus. I think Judge Williams is familiar with that, and so is the PD's office. So we
Who
are
else has
actively
signed
working on
off?
that.
What other law enforcement agency has signed off besides BSO? Anyone?
He submitted them to the other law enforcement agencies. I don't know that they've been signed off on yet.
Can you share with us, will he be following back up with those chiefs, or what's the strategy for getting the other law enforcement agencies to sign on?
he's got the Chiefs meeting next week as well, so he plans on addressing it again at the Broward Chiefs meeting next week. He's also individually met with those chiefs, so again, this will be the second time that he'll be, educating them on the MOU. And obviously, I'm going to get with him because if I need to do the same thing on a more ground level presentation, I'll be doing the same thing. As I'm getting those phone calls, and I can tell you that when law enforcement officers are calling in and they're trying to understand the new policy because they're recognized, the JAC also has been instrumental in making sure that we've been called. That was the call that I had last night. The child had actually been brought to the JAC. DJJ knew to call us. Then I got on the phone also with the deputy. I explained the policy to him. He's passing that word along. I think word of mouth is going to be helpful as well, because the more officers that call in, the more they'll understand that they're supposed to call. But yes, he is meeting with the chiefs again next week and bringing that up, Madam Chair.
But to your knowledge, only BSO has signed off as we sit today.
In terms of signing off, but every agency has the policy. I don't think anybody's rejected the policy, but I will circle back with that.
I understand that, but my point was that when it was proposed to, we talked about it and it was brought up to the sheriff of here, Broward County, and he learned that that is something that, first of all, this isn't new except for maybe the age bump down. This was practiced, but it wasn't a policy, but it was practice. It's been done under the stats administration. However, it wasn't done holistically. So you had people, even the colonel did not know that that's what we were going as as soon as he found out, he started to reach out and embrace it and got the sheriff department ready to sign off. That's not the same thing as other departments. And as I expressed, as I have gone to meetings with law enforcement, because we're meeting for other things, they're not aware of this policy. And in my mind, and there are plenty of attorneys on the phone, until they sign off on it, then that's not really, worth the paper is written on, because they're not signed off on it. So to me, buy-in would be for the chief to step up and say, we concur, and to share that information and have that policy within their own department. So Colonel, you know how these things work. Would you concur that it would, if the chief signed off and then made it a policy to all the troops, then that would be more likely for it to happen as opposed to the officer that knows about it or doesn't know about it, or knows that it's practice or it's optional, I guess I should say. Would you concur, Colonel Holmes?
Yes, I would concur 100%. It starts at the top. And these chiefs have to mandate, and they have to mandate it by putting it in policy that is required for their officers.
Okay, and so I would hope that there would be a strategy developed. As I said many times, I've gone to those for the chiefs meetings. You ain't got yourself nothing there. These guys are extra when it comes to that. So if anything comes out of it, that would be great. I would be surprised if you got any without meeting person to person with those guys and capitalize on the relationships, then it's going to be, they sit, they listen, they give you a few minutes and they say, okay, next on the agenda. So I would hope that we would do some additional things. I know there's plenty of people on this phone that have relationships with law enforcement and had some work with them on several different issues where we can help to move this along now that they have this on deck. So and Ms. Evans, you have your hand up. I'm sorry.
Thank you, Madam Chair. What I would add to the dialogue regarding Judge Holmes, and then it was kind of the dialogue between Judge Holmes and Judge Williams about the Florida statute. I think in this process, Gordon, if you could just make a note of this, I think it's critically important that law enforcement agencies, when they make the decision to arrest, regardless of what the statute says, that they also follow the other statute that requires them to give the reason. So when we have exceptions, and I'm going to air quote that, we can then begin to look at those trends and determine programmatically what perhaps we can do different or better to serve a particular population. And I know we have domestic violence on the list as an exception with caveats. That's the majority of our missed opportunities in all the data analysis. That continues to be it. And that's truly something I think that we can overcome. So I just want to make sure, Madam Chair, that we have that out in the public, that particular statutory requirement is not met either.
Can you share with us, since you have the floor, Chief Evans, our missed opportunities for the month of April?
Sure. So I have a couple different sets of data. And so what I'll do is we have the missed opportunity report as defined by the department for the month of April has not been received as of yet. It normally comes about mid-month, the following month. So I do have the quarter one of 2021 to report on. And so I'll give it to you individually, and then I can give you a quick wrap up. In the month of January, we had a total of 26 youth who appeared on the missed opportunity report. Of those who appeared, it's a way we can group together. 14 of those kids were identified as being arrested. Of those 14, 10 were for domestic violence, and so they did not meet our criteria for civil citation, and 4 youth were not domestic violence-based offenses. And just so everyone knows, the definition for the department for the domestic violence, when we receive the arrest report, very similar to what we do when a kid has a school-based offense, it is not on school campus, we have a designation within our data system that identifies domestic violence. And so that's the check mark that we're using. Of those 4 youth, 3 were processed at the Juvenile Assessment Center and 1 was out of custody. The agencies tied to those 4 arrests that were not domestic violence, one was Broward, and there's 1 each, Broward Sheriff's Office, and that offense was a touch or strike. Coconut Creek, and that offense was resisting arrest without violence, resisting officer without violence. Sunrise was 1, and it was trespass, and the reason given was parent decline. And then Lauderhill was trespass, except the one that I gave. So parent decline was Sunrise, and then for reasons for not giving one was for BSO was multiple misdemeanors. What I will say about that one particular case, it was 1 case where every time it was a very odd offense. Every time the offense was seen, they were given a separate count, but it was still 1 misdemeanor. So it was still 1 set. And I actually spoke with the supervisor about the details of the case. Pretty interesting. So again, I think multiple misdemeanors in my mind relates to other arrests or other referrals that were created. This was still the same single incident. So that was just unique in that particular case. And demographically, of the 4 youth, 3 of the 4 were Black males and 1 was a white female. And that was the resist without violence. For the month of February, we had a total of 16 youth. Of those 16, 6 were arrested, 4 for domestic violence and 2 were not for domestic violence. 3 were taken to the assessment center and 1 was out of custody. The respective agencies to those 4 arrests were Hollywood, and that was for trespass of a 12-year-old Black male. For the second one was Broward Sheriff's Office for obstruct justice, 17-year-old white male. For the last remaining 2, they were both from Coral Springs for loitering and prowling, both 15-year-old Black males. And for all 4 of those arrests, there was no reason given for those. So I could not, I'm unable to determine from our data set what perhaps the officer was thinking along the way.
And Chief Evans, does statute speak to giving a reason?
Yes.
And what does it say?
I can't quote it verbatim, Madam Chair, but it basically says that it was written, what am I in, 21, so maybe 2018, where if, because of the way the statute compels, that if for some reason discretion is used, that the law enforcement officer must provide a reason, and it's about 13 reasons that are given. As a conversation I had earlier today, so after we met, that from a state level, FDLE is actually looking at changing the arrest report and requiring those reasons be given before they can even move forward with completing the arrest. So it's certainly statutorily driven. And when I find it, I will certainly send you all. And I know Judge Holmes will want the actual statute number that drives that. So I will get that for you.
Did you say it was in a prior version of the 985-12?
It's a 985. I can't quote it to. I can't tell you exactly where it comes from.
I've got 985-12, but it's not in the civil citation. So
I'll find it.
I'll find it and I'll text it to everybody.
Okay. Perfect.
I mean, I'll put it in the chat. All right. Thank you.
I may be able to find it. Tamika may be able to find it too, because we have it on a letter. And then so for the month of March, conclude here, we had, well, with this said, we had 19 youth who were arrested, 19 youth in that population, 12 were arrested, 9 were for domestic violence and 3 were not. Of those 3, they were all out of custody. And the 3 respective agencies, one, and in no particular order, I know Colonel Holmes, I keep calling them BSO, is the order in which they appear on the report. BSO was for trespass. I did review that case, a trespass charge for a 16-year-old Black female. There were additional disqualifying charges within the arrest set that included the misdemeanor. So it did have felonies there. The other 2 were for Coral Springs. One was for misdemeanor drug offense, marijuana possession of a white Hispanic. I want to say that was male. And then the second one's for loitering and prowling, 15-year-old white Hispanic male as well. And again, for all 3 of those, there was no reason given as to why that was done. So if you look at the data in its totality, BSO and Coral Springs had 3 youth each who made just this data set. Creek, Sunrise, Lauderhill, and Hollywood had 1 each. What was consistent, unfortunately, is that of those cases, the majority did not have a reason given. And it was about 50-50 split between those that were out of custody and in custody. Of those who made the list, the majority of the population continues to be domestic violence. 21 of the total were for domestic violence. So again, we still have, I think, a golden opportunity to better serve this population. So that's missed opportunities as it is represented in our database. So I have another, I'll pause there to see if there are any questions, because I have another data set that looks at it a little bit differently, that talks about kind of what happened thereafter. So.
Any questions or concerns thus far? Go ahead, Chief Evans.
Okay, so we have another report that is able to, where you're able to see also on our website for first-time misdemeanor cases resulting in delinquency processing. And so it lists the entire state. And so Tamika and I were looking at some data points, and I decided to do the year in review. So from April 1st of 2020 to April 30th of 2021, first-time misdemeanor cases resulting in delinquency processing. This yielded some definite different results. So we had 172 youth who were on that report. Of the 172, the top 5 agencies contributing data who contributed to that set. One was Broward Sheriff's Office with 34. Coral Springs had 31. Lauderhill had 23. Hollywood had 15. And then Miramar had 14. And the respective agencies, I can send this out, had single digits. And so of this, I want to give you all the race ethnicity breakdown, primarily Black males. Of the 172, it was 100 and, if my eyes are right, it's like 115 Black males. 115 of that, 115 were Black, and then 34 were Hispanic. So still children of color make up the majority where this opportunity was not presented. I did not go to a case level to review what may have caused that, but that was in this data set. What I found interesting, while I say probably statistically trend line that domestic violence is the majority of our missed opportunities, when I delved into the data for BSO, 8 of the 34 were not for domestic violence, so a small percentage. For Coral Springs, 19 of the 31 were not for domestic violence. So half of their cases, just on the surface level, would have qualified for domestic violence. For Lauderhill, 7 of 23 were not for domestic violence. This was definitely a large amount here. For Hollywood, 10 of the 15 were not for domestic violence. So again, potentially 10 young people who did not have to be taken into custody. And then for Miramar, they had 3 of 14. So the charges related to, so that's a way of looking at it in a year's time, because month to month, the numbers have been small because of COVID. What I can say just for the month of April, using the same data set, loitering and prowling, trespass, assault and battery, and petty larceny were the ones that made the list just for the month of April 2021. So that's the data report, Madam Chair, and what I'll say as far as just outcome-based data. Arrests do not change behavior, period. It does not. It, as a matter of fact, it may have the counter effect on most of the children who are exposed to the criminal justice system. Immediate, appropriate assessment and intervention changes a child's behavior. Civil citation is probably the best way. We assess the needs and get the services in place within days. These cases that I looked at, some of them are still on intake. So we've lost 3, 4, 5 months of intervention as required by, the opportunity presented of civil citation. So I think in addition to us marketing, not even marketing, but presenting this to law enforcement, the notion that an arrest actually creates public safety could not be substantiated statistically. So I think that somehow that message has been lost along the way. And bringing a young person to the Juvenile Assessment Center or doing the paperwork to get to the clerk of the court is seemingly the best, maybe just the methodology used today, but it's not yielding any positive outcomes for our young people. And that concludes my report, Madam Chair.
Okay. I want to pivot to certainly a champion of children, and she's been very busy. We haven't had a chance to talk at all, but whenever you start talking about children and arrest and protecting our children, certainly I wouldn't want anybody with me with their setup other than Dr. Osgood. So Dr. Osgood, let's hear from you. You've heard the reports and you've heard what was done, what may be done, what has been done, and what may most likely, what hasn't been done. So tell us your thoughts about today.
Thank you, Madam President. Thank you for your leadership and your continued push in this area. We know that when those kids are arrested, it also means that they're out of school for multiple days, and it's very hard for us to get them reacclimated on track, especially now that we've just had COVID. So those arrests cause a major impact in their lives overall. But we continue to deal with this issue in the state of Florida, where there are some people that look like us and others that think that kids should be arrested and that they should go to jail even for minor and petty things that they do. Today, I've been dealing with a recent graduate of Plantation High, former football player that got gunned down last weekend, and his brothers on the football team. All of the kids are just in turmoil today. Our kids are dealing with a lot of trauma, a lot of issues just living from day to day. So everything that we can do to help them to stay on a positive track, to show them grace, is what we need to be doing. And I think as we continue to work through this and be aggressive, and thank you so much, Judge Holmes, for many of your comments that you said about the loopholes, because those loopholes is what continue to hurt our children and ultimately hurt our community as a whole. So I am always disturbed about children being arrested unnecessarily in our school system. Mr. Watkins, Dr. Wanza, Mr. Runcie, it's been a major focus of ours. And we've taken a lot of hits for it, but those are hits that we will continue to take. But I just think we have to understand the urgency of this issue and the importance of keeping our young people out of the criminal justice system, keeping them from being arrested. Once you're arrested, even if you have not been found guilty, I'm speaking from experience, it's something that you never forget. It's a dramatic, dramatic experience. Even if the officers are polite, it's a dramatic experience, just having to go through any of the process. So thank you to all of you that are committed to fighting for our kids and helping them be in environments that's going to help them achieve academically, help them not have their lives ruined over something very, very trivial, a lot of simple mistakes that, you know, we may make in other ways and not get arrested for it. And I just think as we continue to work with law enforcement, and, you know, since BSO seems to be aggressively doing this, you know, maybe sharing the best practice and trying to work with the law enforcement office. I just think that that has to be our focus. We can continue to try to pass the buck to the judges, the state attorneys, and all of those, but it's the cops that's on the streets that are using discretion and making most of these decisions. And as I just heard Chief Evans run down the data, I was a little surprised that Coconut Creek didn't have more incidents, since they like, you know, ammunition sniffing dogs and all that other kind of stuff to police our children. But that data does not lie. And I think where we have those data marks, we have to put a major focus on those, because the data is the evidence that apparently they're not getting it. So thank you to Commissioner Holness. I know you've been doing a lot of work around civil citation, and certainly to Mr. Weeks and you, Madam President, and all of you for everything that you do. And Judge Holmes, thank you so much for not sitting home in retirement. Thank you for serving the community and being a voice and helping us with these issues. I'm so glad you didn't just take your ball and go home. And continue to pray for us at Broward County Schools. We're in a crisis, but we're going to get through it. But continue to pray for us and pray for our superintendent of schools.
Absolutely. Thank you, Doc. Judge Holmes.
Madam Chair, I think I've said it all. If we can just work a little bit more diligently on this. You know, I know Mr. Pryor has started a new endeavor, but we need his 100% participation and cooperation in these efforts to, you know, save our children. And that's the important thing. So I'm very proud to be a part of this august board, and I plan to make my presence felt. We've got a lot of work to do to keep our children out of jail, because, you know, basically the system, if you look at it, it was never set up for Black children to be in schools. They were to be in the fields working. So, you know, all I can say is we got our work cut out for us, and I will make sure that I lend whatever legal prowess I have to making sure that Black and brown children get a fair shake in the system. So thank you, Madam Chair.
Ms. Monticello, did I see your hand go up? Not your hand, your physical hand.
Yes, thank you, Madam Chair. I have two things. One comment I want to make. I did have an opportunity to reach out to Mr. Pryor while we were all speaking about other matters to find out about the MOU policy with regard to 12 years of age and younger. And he did say that those remaining chiefs that he met with that have not signed off on the policy yet are having their legal counsel review it, and he's awaiting signatures for the actual policy. So that hopefully gives you an update on where we stand with those remaining agencies outside of BSO, who's obviously already signed off, and DJJ. And then secondly, I just have a question of Chief Evans. First, I want to say that Harold wanted to thank Chief Evans because I know she assisted him in getting some data together last week ahead of his meeting with Children's Services Council. I should comment, because I don't think I had an opportunity to mention this. I know you all know that he met with, I believe you know, based on what we're listening to the discussion this afternoon, that he did meet with the CEO for CSC, and that I mean, he'll speak to this obviously when he's addresses all of you together again, My understanding briefly from getting debriefed on that meeting was that it sounds like Children's Services Council position is that their funding is really in place, and maybe Chief Evans can respond to this as well. But because it sounded like she might have been at that meeting or was aware of it. And if I'm misspeaking, she'll correct me. But their position is that their funding is there for sort of the back end for diversion purposes. I guess it took the CEO a little off guard with regard to funding upfront on a staffing issue at the JAC. And I think she wanted State Attorney Pryor to possibly go to the county to see whether they would be in a position to fund something like that. So I know that Mr. Pryor would have told you today that he's still trying to figure out the funding for the screening process. And I don't know that numbers were even discussed in terms of cost and how much we're going to need for that. Because I agree with Commissioner Holness that I don't know that it would require a lot of money. It might just be a matter of a position. So I wanted to address that because I didn't do that earlier. But my question to Chief Evans is, of that number with the 172 youth that you had talked about and have broken down so detailed for us with the agencies, you were left with loitering and prowlings, trespass, and petty thefts that looked like they had not been given opportunity for civil citation. Is there any way, and I don't know that you would know this, to know whether any of those contacts with law enforcement involved youth whose families could not either be contacted to get a response from them, or a family member who said, just take them to the JAC? Because that's been my experience so far, sometimes with some of those midnight calls. And I know we've addressed that before, and I know even Judge Williams has brought that to to our attention, that sometimes when they're making that arrest or transporting that youth to the JAC, it's simply because they can't reach anybody in the field, or they're having, as I've had recently, a mother say, take them to jail. Do we know whether out of those cases, any of that was taking place and that was their last resort? I'm just curious.
So, Ms. Michelle, of the data set and that what I gave for those reasons, that was particularly just for April of 2021, because they're not giving the reason, we don't know the reason. And so I'm looking here at that set of 15 youth, again, 11 of them being for domestic violence, which I can see from our system. Those 4, I'm looking here, and outside of 2 reasons given for domestic violence, there's no other reason other than not identified as civil citation eligible. It doesn't allude to that. There is this particular reason that says parent refused or denied. There is that reason. So we will have to go case by case on this to determine what actually occurred here. And interestingly enough, to your point though, they're going to get to the Juvenile Assessment Center and they're going to process the kid, and the parent is still going to have to come. 99% of the time, that's who comes. So all you've done is delay the same process.
But they don't always come, because I had that issue just recently. I'm just giving you a real-time issue where they made those efforts in the field. They got all the way to the JAC. They, of course, then called me. We had a whole discussion between DJJ and the arresting officer, and that kid sat there through the night till the detention hearing because the JAC could not reach a parent or a guardian. Of course, they did not send him any further past the JAC. He literally slept on a chair all night because they were not going to send him to a detention center or anywhere else. He scored for home detention.
Right.
That is a real problem, and I don't know.
How often does that happen, though?
Not
happening. I know there's going to be exceptions, but let's not act like that's the general rule. Of course, it will happen. But
no, I'm not suggesting it's a general rule, but I do think when we
let's not let that be an excuse for them not doing what they're supposed to do.
No, of course not. But when we break down data, and I think to Chief Evans' point, and what she was saying earlier, which is her ongoing frustration is that law enforcement is required to put their reasoning. It would be helpful to know that, because once we break that data down, if we get to the point where those missed opportunities, if civil citation works out the way that it should, and we're having missed opportunities still, and we can identify them as something other than, it's not, domestic violence is not a missed opportunity because it simply is ineligible. So if we're getting down to loitering and prowling and trespassing and petty theft, And we're finding that those are situations where that youth could not have a family member or a family member refuses to pick up that child, or they can't be reached. Then we are going to have to address that in another way, because that's still a concern. We of course want to make the child, and we want to reach the child in a whole capacity. I'm just suggesting that I know that those numbers exist, that sometimes that is the reason, and we do need to require law enforcement to tell us why, so that we know that. So I do think that the Chief Evans' point earlier, if we can impress that upon agencies while we're trying to get them to roll out civil citation, that would be helpful.
And I also know that in Miami-Dade, they released to a responsible adult. So they may not be able to get to mom because she's working, but they have someone that's 18 or older to fill in the gap to pick up the child and be responsible. I know that some agents, for example, Fort Lauderdale specifically put it in their SOP because they mirrored some of what Miami did. So there are other things that can be done, because a lot of times if mom is on her job and she don't work, they don't eat, a lot of times she can't come, or, so there are always extenuating circumstances. Should it be addressed? Sure, but let's not act like that's, like an everyday. But I think if the officers followed the statute and did say the reason why they were not given, that would certainly be in order for them to do. And finish, Cassandra, and then the judge.
I would say that problem releases is what we call them. For that particular young person we're talking about, it's resulted in a call to child protective investigation. It is a lot of family dynamics. We'll get that throughout the month, maybe once or twice between detention and the Juvenile Assessment Center. It kind of depends on the circumstances. So it does happen where DCF is called and have to respond and shelter a kid. So out of 12 months, we may have 12 cases, maybe 15. So, but to Gloria's point, I think it's crucially important for us to know the reason why as we begin to try to facilitate a stronger system.
Judge Holmes?
I just want to weigh in on statutory construction here. Ms. Evans pointed to a statute 985.126. We're dealing with 985.12. And while they're in the same volume, we have to be very careful with asking for reasons, because 985.126 deals only with diversion programs. 985.12 is not a diversion program. It's a pre-arrest. Diversion occurs after arrest. And, 985.12 is a pre-arrest statute. So we got to walk very careful with demanding to know why, because the statute is real clear. For diversion programs, the officer must indicate why. So, if I've never seen the form for civil citation, but maybe we can just get them to check a box, and not say anything. But when you start demanding, the legislature is going to look at it and says, oh, this is pre-arrest. Okay, let's make this a diversion program. So that means you have to arrest to get diversion. There's a difference. It's a fine line. And statutory construction does not allow you to mix them, because the statute is very clear under 126 that for diversion programs, and it says that 985.12 is not a diversion program.
Well,
I just pulled the statute and read it.
I remember BSO required that their deputies, if they were not going to offer a civil citation program, they had to say why they weren't going to. That was an interagency thing that was put in.
And we can slip that in. We can slip that into the memorandums of understanding. If you're not going to get the pre-arrest, then can you tell us why? But I'm scared to start doing that, because if you're going to get legal counsels to start looking at all of this, they're going to find that wiggle room, and they're going to say, oh, if this is diversion, then we can arrest them. So the legislature messed up by putting a lot of things in places, but I'd be very, very careful. I'll study 126, but 126, the first thing that popped out to me was for diversion programs. If the officer is not going to agree to diversion, then the state attorney's office is going to look at that and say, yeah, that's diversion. What we're talking about is not a diversion program. It is a pre-arrest program, but not diversionary. It has the function of diverting young people out of getting arrested. But, Ms. Masala, if your office has a different definition for diversion, let me know. But I think we can still slip it in, but I don't know if we can make it mandatory to
The
take
agency
action.
can make it mandatory,
I
Judge, and
think
that's
we
what we
did
Yes,
want.
slip it
that's
in.
what
Want
I'm
the
saying.
agency to do it, just
in
as
the
BSO,
agreement,
Fort
Judge.
Lauderdale, and Hallandale did. That's what we want.
Yeah,
I mean-
I agree with that. We can put it in there,
We
but I'm
did,
just saying,
yeah.
Miss Evans said there's a statute that says they have to. And I'm trying to make sure that we are correct. That statute does not apply to pre-arrest.
Madam Chair, if I may, to Judge Holmes, interesting enough, and we certainly can explore this in our subcommittee. This argument arose with the definition of promise being a prevention, diversion. What type of program was it? And in the general counsel of the department, when this statute was written, as a matter of fact, maybe a year or two after MSD. Right. And so it's in that section, but I do believe it's in another section. So I'm going to do some additional homework before we meet again and share that with you. But in the conversation that included promise, and we went back and forth, and Judge Williams, you remember this with the collaborative agreement, we were changing the language and we were cleaning some things up. And it came up again, and the then school board attorney, Ms. Myrick, stated, hey, the school board defines it as such. And I want to say that the section for that, the argument that was used at the section spoke to pre-arrest and diversion, all in the subtitle. But of course, I defer to the attorneys, but I'm going to do some homework to pull that for you.
Yeah,
I'd
I'd like to look into that, because you can't mix apples and oranges, because that's why people don't like programs like this, because they're saying diversion, well, you can arrest, and most judges would make that ruling, because 985 is specific. It says diversion program.
Okay, we can clean that up through the interagencies. I mean, and I know that we did 3 agencies for sure that we did not have an issue with. That was BSO, Fort Lauderdale, and Hallandale. So I believe that Colonel Holmes committed earlier in previous meetings to continue on that as they audit their missed opportunities. I think we should do that as well with the other agencies as well. And I want to take this last 5 minutes to say to the Colonel, what's your population? How many juveniles do you all have down there?
We currently have 8 juveniles in custody at the Paul Ryan facility. They're all in classes and they're receiving counseling. 0 has tested positive for COVID. Right now in our entire jail system, we only have 1 person that's tested positive for COVID. That's at the main jail, and that's an adult. But as far as juveniles, we have 0.
Thank you. Chief Evans, what y'all got? You're muted.
All right, my space bar didn't work. Okay, for the Broward Regional Juvenile Detention Center, for staff, they've, and this was just earlier this week, a report of 38 staff who've tested positive, with 35 who have been cleared. As far as youth are concerned, there have been 7 positive youth, with 7 youth cleared. They're currently under quarantine as of my notification on 5/3 to clear quarantine on 5/15, which is Friday. And as far as population, the secure detention population it has 31 youth, all males in secure detention. And that was earlier this afternoon.
And since you're on the quarantine, everybody, the education piece has to continue virtually.
Correct.
And then that means, Mr. Weeks, your lawyers are seeing your clients virtually as well, correct?
Yes, they are.
Okay. All right, is there anything that we have left out? We want to.
Madam Chair, if I may.
Go right ahead.
If you could grant us an opportunity to use the Zoom after the meeting just to coordinate the date for the subcommittee, since all the members are on.
Absolutely.
Madam Chair,
to
COVID, what I will say is with the governor's recent executive orders, I think 101, 20, and 21, I believe maybe the numbers, the department is moving back towards reopening, incrementally, but by June 1st, that we will be back open fully to the public. Here in Broward County, we have not closed our offices. And so we are acting upon those orders with the June 1st reopen posture. Well, again, with appropriate safety protocols. So that's where we are as it relates to the statewide executive order from the governor.
And to Dr. Wanza and Mr. Watkins and Dr. Osgood, what does that mean for your teachers that are assigned to the detention center?
So, so I'll let Mr. Watkins speak for the detention center, but I'll just speak globally for the district. All teachers were back to work since January. So of course, our teachers have to conform to what are the protocols of the respective, agencies that they're assigned to. But we have come out, the superintendent came out and said that in August, when the new school year starts, we are back to 100% in-person instruction. But of course, we have to make sure that we comply with whatever the protocols are for the respective facilities. So Mr. Watkins, you can.
I think you answered it. We're 100% in person, and DJJ's had to be in person for quite some time.
And will the children, I'm not sure who answers this, will they wear a mask when our teachers go back in there? So that if you have a teacher who is yet uncomfortable working in that petri dish, how does that work?
So the safety and security procedures are under the control of the facility. So that the appropriate person to answer that would be the superintendent of the facility. They tell us how the rules are, and then we work to follow them.
Okay. Superintendent is in witness protection still. Superintendent of the facility. Okay.
On the community side, on the probation.
Our superintendent for schools, y'all superintendent.
Okay. That'll be ours, DJJ ours. What I can say for the mask mandate as it is outlined in the governor's executive order, it removes the ability to enforce that. So for staff and all visitors, it becomes voluntary. Most of our staff have continued to wear them as a matter of personal protection, but we're no longer able to require that of any guest or visitor or any youth who come into our facilities. Into our offices. I'm not going to speak to the detention center who come into our offices. So I'm anticipating it to be very similar at the detention center, but they may do something different because, to your point, the petri dish is a different environment than a community-based office.
Thank you. Any other?
Madam Chair?
Yes.
You either need a motion to adjourn or motion to extend.
We are adjourning, and we're gonna stay on for those special committees. And we said that a little earlier. So is there anything else that is burning to anyone?
No, ma'am.
Said that. We are adjourned. Those people who are going to stay on for the committee, please do.
Holmes, could you stay on?
Colonel, yes, and Judge. All the homes stay on.
That's it. Gotcha.